The Supreme Court just issued an emergency ruling that will fundamentally reshape gun rights in America, and what they decided will shock you. For decades, states have maintained ironclad control over who can carry firearms through complex permit systems, mandatory training requirements, expensive fees, and months of bureaucratic waiting periods. But in a stunning midnight decision that caught legal experts completely off guard, the nation's highest court has declared that era officially over. Americans will no longer need government permission slips to exercise a constitutional right. If you care about the future of the Second Amendment and constitutional freedom in this country, you need to hit that subscribe button right now, because what I'm about to reveal will change everything you thought you knew about gun rights in America. This isn't speculation, this isn't theory, this is happening right now, and the implications are absolutely staggering. Let me explain something that most Americans don't understand about how the Supreme Court actually operates. The court receives approximately 7,000 petitions every single year. Out of those thousands of cases, fewer than 80 ever make it to the regular docket, where they receive full oral arguments, detailed briefs, and months of deliberation. But there's another pathway that very few people know about. It's called the emergency docket, and some legal scholars refer to it as the shadow docket because of how quickly and quietly it operates. The emergency docket is reserved for constitutional crises that demand immediate resolution. We're talking about active executions, contested elections, federal vaccine mandates, or situations where irreparable constitutional harm is happening right this second. When the Supreme Court issues an emergency ruling, there's no negotiation period, there's no gradual phase-in, there's no appeals process. Lower courts must comply immediately, and state governments must adjust their laws right now. The last time the Supreme Court deployed emergency powers for a constitutional rights case of this magnitude was during the most contentious voting rights disputes in recent memory. Those emergency rulings literally reshaped entire election systems overnight. Polling places changed. Voter ID requirements were struck down in hours. Election officials scrambled to comply before voting began. That's the kind of power we're talking about here. But here's what most people don't understand about emergency rulings. The justices don't just issue a narrow order to stop immediate harm and then walk away. They use emergency rulings strategically to telegraph the court's broader constitutional philosophy. They lay the groundwork for sweeping permanent changes that will follow in future cases. And that's exactly what's happening right now with firearm permits. Right now, at this very moment, approximately 21 million Americans hold active concealed carry permits across the United States. That number represents years of their lives spent navigating bureaucratic systems, thousands of dollars in collective fees paid to state governments, hundreds of thousands of hours completing mandatory training courses, and months upon months of waiting for government approval that they had the permission to exercise a constitutional right. These 21 million permit holders did everything their states demanded. They submitted fingerprints, they provided character references, they sat through safety courses, they paid processing fees, renewal fees, and administrative fees. They proved to government bureaucrats that they were worthy of exercising their Second Amendment rights. And now, in a single emergency ruling, the Supreme Court has potentially declared that entire system unconstitutional from the ground up. Let me paint you a picture of what this actually means for real people. A Texas resident who paid $40 for a 5-year license to carry just saw that requirement potentially eliminated overnight. But that's actually one of the cheaper scenarios. A California resident who spent $300, waited 8 months, provided character references from community leaders, and submitted to an in-person interview with law enforcement officials might have done all of that for absolutely nothing. New York City residents faced one of the most restrictive permitting processes in the entire country. We're talking about multiple interviews with police officials, notarized documents, proper cause statements explaining exactly why you needed to carry, reference letters, and processing times that could stretch beyond a year. Some applicants waited 18 months only to be denied for reasons that were never clearly explained. Those permits could now be invalidated simply because the Supreme Court has ruled that permits themselves constitute an unconstitutional infringement. But there's a deeper issue that nobody in the mainstream media is talking about, and it's going to create absolute chaos in the coming months. Reciprocity. Currently, permit holders can carry firearms in states that recognize their home state's permits through reciprocity agreements. These agreements are the backbone of interstate gun rights. A Florida permit holder can carry in 36 other states because Florida has reciprocity with those jurisdictions. But here's the massive legal puzzle that's about to unfold. If permits no longer exist because they're unconstitutional, what happens to reciprocity agreements that are based on permit recognition? Does constitutional carry automatically become nationwide? Can a resident of Vermont, which has never required permits, now carry in California, which has some of the strictest gun laws in America? Do states still have the power to restrict non-residents, even if they can't restrict their own residents? Here's a number that's going to blow your mind. American gun owners have collectively paid over $1.4 billion in permit fees over the past decade. Let me say that again. $1.4 billion. That's not counting renewal fees. That's not counting mandatory training course costs. That's not counting fingerprinting charges or background check fees. We're talking about $1.4 billion in pure permit application and issuance fees paid directly to state governments. The fee structures vary wildly from state to state, and that variation is part of what makes this system so problematic. Some states charge $20 for a basic permit. Others charge $500 or more when you add up all the required components. California's system is particularly egregious. When you factor in required training courses, processing fees, fingerprinting services, background check costs, and renewal fees, California applicants can easily spend upward of $800 to $1,000 just to exercise a constitutional right. Think about what that means. If you're a working-class American living paycheck to paycheck, spending $800 on permits might be impossible. The permit system doesn't just infringe on constitutional rights. It creates a two-tiered system where wealthier citizens can afford to exercise their rights, while poorer citizens are effectively priced out of Second Amendment protections. That's not equal justice under law. That's constitutional rights for sale to the highest bidder. But here's the real bombshell that has state attorneys general absolutely terrified right now. Multiple states are already facing class action lawsuits demanding refunds for permit fees paid within the statute of limitations. If federal courts rule that permits were unconstitutional all along, then every single fee collected under those permit systems was collected illegally. That's not a policy disagreement. That's potential government theft of constitutional rights through illegal taxation. New York alone collected approximately $380 million in permit-related fees over the past 5 years. California collected even more. Illinois, Massachusetts, New Jersey, Maryland, and Hawaii all operated expensive permit systems that generated massive revenue. The potential financial liability for states runs into the billions of dollars. And that's before we start calculating damages for civil rights violations. 26 states currently require some form of mandatory training before issuing a carry permit. These aren't casual suggestions. These are legal requirements backed by criminal penalties. Course requirements range from 4 hours on the low end to 16 hours on the high end, covering everything from basic firearm safety and legal use of force doctrine to marksmanship qualifications and state-specific carry laws. Approximately 3.4 million Americans complete these mandatory training courses every single year. The Supreme Court's emergency ruling potentially invalidates every single training mandate in the entire country, not just the expensive ones, not just the burdensome ones, all of them. And here's why. Constitutional rights don't require competency tests. You don't need to pass a First Amendment literacy exam before exercising your right to free speech. You don't take a Fourth Amendment course before expecting privacy in your home. The government can't mandate voter education classes before you cast a ballot, even though an informed electorate is crucial to democracy. But here's where this gets really complicated, and this is something that creates genuine tension even within the gun rights community itself. Many gun owners actually support training requirements, even if they oppose permit systems. Surveys show that roughly 68% of gun owners believe some form of firearms training is valuable and important for responsible gun ownership. They recognize that handling firearms safely requires knowledge and practice. They understand that knowing the legal boundaries of self-defense can prevent tragic mistakes. The gap between constitutional principle and practical preference creates a genuine philosophical debate. Eliminating training mandates might be constitutionally correct under a textualist reading of the Second Amendment, but it raises legitimate questions about preparedness, responsibility, and public safety. This is one area where strict constitutional interpretation and practical policy considerations don't align perfectly. Even with permits eliminated, the Supreme Court has acknowledged in previous rulings that certain locations can restrict firearms as so-called sensitive places. But here's the massive problem. Nobody agrees on what actually qualifies as a sensitive place. And that disagreement is about to become the next major battleground in Second Amendment litigation. The original historical examples from the founding era were very limited. Courthouses where judicial proceedings took place. Legislative buildings where lawmakers convened. Polling places on election day. That's basically it. We're talking about maybe 3 or 4 specific location types where firearms restrictions had clear historical precedent. But modern interpretations have expanded that list so dramatically that it's become almost meaningless. Post offices, public parks, public transportation, including buses, trains, and subways, sports stadiums, hospitals and medical facilities, college campuses and universities, bars and restaurants that serve alcohol, churches and houses of worship, and in some jurisdictions, even streets and sidewalks within 1,000 feet of schools. New York's response to the Bruen decision in 2022 was particularly egregious. The state legislature basically declared virtually all of Manhattan a sensitive place. Times Square, sensitive place. Subway system, sensitive place. Public parks, sensitive place. They created a patchwork of restrictions so complex that even legal experts couldn't figure out where carrying was actually legal. California went even further with default prohibition schemes. The state declared that all private property is a sensitive place unless the property owner explicitly posts signage permitting firearms. Think about what that means. You can't carry in a grocery store unless the owner puts up a sign saying guns are welcome. You can't carry in a shopping mall unless the mall operator explicitly authorizes it. That's not a sensitive places doctrine. That's a default gun ban with narrow exceptions. The emergency ruling strikes directly at these expansive interpretations, but it doesn't eliminate the sensitive places doctrine entirely. That's going to create years of litigation as courts determine where the constitutional line actually falls. If the Supreme Court's interpretive trend continues, the list of genuine sensitive places might shrink dramatically. We could be looking at a return to the historical baseline. Courtrooms where trials are happening, prisons and jails, legislative chambers when the legislature is in session. Everything else becomes constitutionally protected for carry. Here's where this emergency ruling becomes an absolute nightmare for state governments. The Supreme Court issued this decision, but they didn't provide a detailed implementation roadmap. They didn't give states 6 months to adjust their laws. They didn't create a grace period for existing permit holders. They issued an emergency order that takes effect immediately, and now 50 states with 50 different permit systems are scrambling to figure out what they're supposed to do. Constitutional carry states like Vermont, Maine, and New Hampshire are actually in the easiest position. They never required permits in the first place, so nothing changes for them. Their system's already aligned with what the Supreme Court has now mandated nationwide. But then you have shall-issue states like Texas, Florida, and Pennsylvania. These states maintained permit systems, but they were required to issue permits to anyone who met objective criteria. Their permit systems weren't as restrictive as places like New York or California, but they still required government permission for carry. Those systems are now constitutionally suspect. But then we get to the may issue states, and this is where the chaos reaches peak levels. California, New York, New Jersey, Massachusetts, Maryland, and Hawaii all operated may issue systems where local officials had discretion to deny permits even if applicants met all objective requirements. Most of these states responded to Bruin by keeping their permit systems but removing discretion. They converted to shall-issue frameworks where permits had to be granted if applicants met objective criteria, but they made those objective criteria as burdensome as possible. Now the Supreme Court has pulled the rug out from under that entire strategy. It doesn't matter if your permit system is shall issue rather than may issue. The fundamental requirement of getting government permission to carry is what's unconstitutional. These states have to completely dismantle regulatory frameworks that they've built over decades. Here's an angle that almost nobody is talking about, and it's going to create massive confusion on the streets over the next several months. Law enforcement officers across the country are now in an impossible position. For decades, they've been trained that someone carrying a concealed firearm without a permit is committing a crime. Officers could demand to see permits. They could arrest people for carrying without proper documentation. That enforcement mechanism is now potentially unconstitutional. But police departments haven't updated their training yet. District attorneys haven't issued new prosecution guidelines yet. State legislatures haven't repealed their permit requirement statutes yet. Different police departments are going to handle this differently, and that's going to create enormous disparities in enforcement. Some departments will immediately stop enforcing permit requirements. Others will continue enforcement until their state legislature officially repeals the relevant statutes. The lack of uniformity is going to create situations where identical behavior results in arrest in one jurisdiction and no enforcement action in another. What we're witnessing goes far beyond gun rights. This Supreme Court emergency ruling represents a fundamental shift in how the judiciary views constitutional rights and government regulation. The court is sending a clear message. Enumerated constitutional rights cannot be subject to permitting schemes, licensing requirements, or government permission systems. If it's in the Constitution, you don't need a license from the government to exercise it. The Supreme Court has fundamentally rewritten the rules governing gun rights in America, and what happens over the next several weeks will determine just how far this constitutional transformation extends. State legislatures are convening emergency sessions. Governors are issuing executive orders, law enforcement agencies are revising their protocols, and millions of gun owners are watching their rights expand in real time. Make sure you subscribe to this channel right now so you don't miss a single update as this situation continues to develop. Hit that notification bell because new information is breaking literally every single day. Leave a comment below and let me know what you think about this emergency ruling. Do you believe permits were always unconstitutional? What do you think your state is going to do in response? This is your Second Amendment. These are your constitutional rights. The Supreme Court has opened the door to constitutional carry nationwide. Now we need to make sure that door stays open and that states don't find creative ways to close it again through backdoor regulations. Stay informed, stay engaged, and most importantly, stay free.